Stop scrolling and listen closely because the changes I'm about to explain could have a serious impact on your immigration plans. And most people watching this have no idea they are taking effect now. Not next week, not next month, but starting tonight. New green card processing rules are kicking in, and they are already causing major concern inside immigration law offices across the United States. The most worrying part is this. The people who may be hit the hardest are often the ones who believe they are safe. Those who already filed, those who are patiently waiting, those who think their place in line is secure. If you have a pending green card application, if you're here on a work visa, or if you have a family member anywhere inside the U.S. immigration system right now, you'll want to pay attention to every second of this video. Missing even one detail of what I'm about to share could cost you months or years of delay. In the worst cases, it could jeopardize everything you've planned. Welcome back to US Updates Hub, where we closely monitor every meaningful adjustment in US immigration policy, often before it becomes mainstream news. I'm glad you're here because today's update is not a regular informational upload. This is more like an urgent briefing. Stay with me until the very end, because in the final part of this video, I'll explain a specific action step that many immigration professionals are advising their most serious clients to complete before the end of the day. This won't be legal or financial advice, but it's guidance that comes from real-world practice. And simply knowing about it could save you from future complications. Let's begin with what is actually changing, because I know a lot of people are tired of exaggerated headlines and vague warnings. This is not that. These are documented and confirmed policy and procedural changes that are starting to apply as of now, and the number of people who might feel the effects is extremely large. We're talking about roughly 4 to 6 million individuals currently somewhere in the U.S. immigration pipeline who may experience some form of impact from these adjustments. That estimate is not a guess. It's based on backlog figures maintained by U.S. Citizenship and Immigration Services, or USCIS. Here is the core of what's shifting. For a long time, the management of green card priority dates followed a pattern that, while not perfect, was at least somewhat predictable. Applicants from countries with very high demand, such as India, China, Mexico, and the Philippines, have long faced difficult wait times, sometimes stretching 10, 15, or even more years. For most other countries, the system, though slow, generally moved in a way that people could understand and plan around. What's happening now is a restructuring of how certain preference categories are prioritized, how adjustment of status cases are sequenced, and, crucially, how older, long-pending cases are reviewed under a revised framework. That last piece is where many people who think they're just waiting in line may suddenly discover that their assumptions no longer match reality. To understand this clearly, let's step back for a moment. Under the employment-based green card system, there are multiple preference categories: EB1, EB2, EB3, EB4, and EB5. On the family-based side, there are separate categories and queues as well. The unusual thing about the current situation is that these changes are touching multiple categories at once. That is rare. Traditionally, adjustments in policy tend to focus on a specific category, a limited group of applicants, or a specific process. When several categories move or tighten simultaneously, it creates what some immigration experts describe as a cascading backlog effect. Imagine a busy highway where traffic is already heavy. Now picture several on-ramps feeding into the same narrow lane at the exact same time. If your case is anywhere near that convergence point, things can suddenly slow down. Or, for a smaller group, unexpectedly speed up, depending on how you align with the new rules. Consider an example. Let's say we have someone like Timothy, a software engineer who has been in the United States on an H-1B visa for more than a decade. His employer filed an EB-2 petition in 2019. Over the years, he has seen his priority date inch forward, then move backward, retrogression, then progress again slowly. He's renewed his H-1B multiple times, has a U.S.-born child, and has built a stable life, assuming he might be 2 or 3 years away from permanent residence. The new rules could significantly alter that timeline. And it's not just about one nationality, and whether you're from India, Nigeria, Brazil, the UK, or anywhere else. The underlying dynamics may look very similar. One of the most important technical pieces relates to the difference between the final action date and the date for filing on the visa bulletin. If you've ever looked at the monthly visa bulletin from the Department of State and then checked USCIS guidance on which chart to use, you know that these two sets of dates can be very different. Historically, when USCIS determined that sufficient visa numbers were available, they allowed certain applicants to file for adjustment of status, Form I-485, using the more favorable dates for filing chart, instead of waiting until their priority date was current under the stricter final action date chart. This flexibility gave many people crucial benefits. It let them secure their place in line, receive employment authorization, obtain advance parole for travel, and overall live with far more stability while their green card case was pending. Under the new rules, USCIS is tightening when and how they will permit the use of the dates for filing chart. In practice, this likely means that the window to file adjustment of status early, before the final action date becomes current, is narrowing or, for some categories, possibly closing for the foreseeable future. The next major area of change involves how USCIS handles what are known as derivative beneficiaries who may age out. When a parent applies for a green card, their children can be included as derivatives. However, once a child turns 21, they can lose eligibility as a child on the parent's petition. To address this, Congress previously enacted the Child Status Protection Act, CSPA, which in many situations effectively freezes a child's age for immigration purposes. What's changing now is not the law itself, but USCIS's interpretation and internal policy for how they calculate that protected age under CSPA in the context of current backlogs and timing. For families who have been waiting 5, 10, or even 20 years, this shift could mean that some children who believed they were safely protected under CSPA may now be at greater risk of aging out than they expected. We are talking about young adults who have spent most of their lives in the United States, attending school here, integrating into their communities, and now potentially facing uncertainty because of technical recalculations in a policy manual. These are real lives, not just case numbers. There is also an important distinction many people overlook: the difference between what is announced publicly and what is actually implemented inside USCIS. Policy announcements generate headlines and YouTube videos. Implementation generates consequences. In between those two stages lies a period of confusion, adjustments, and internal training, and that is often when unsuspecting applicants are most vulnerable. What often happens is this: a policy shift is published, immigration attorneys revise their strategies, and proactive applicants take steps. But many others, those with older pending cases, those who rely entirely on their employer's HR department, those who filed years ago and assumed no news is good news, may not realize anything has changed until they receive an unexpected request for evidence, RFE, a notice that their case is paused, or an interruption in their work authorization because an I-485 was rejected or delayed for a seemingly small technical reason. That pattern has happened before, and it can happen again under this environment. On the employment-based side, there is another layer: how USCIS sequences the processing of I-140 petitions and pending I-485s, and how it allocates employment-based visa numbers as a fiscal year comes to a close. The U.S. immigration system uses a fiscal year that ends on September 30th. Historically, unused employment-based visa numbers from some categories may be reallocated at the end of the year, and some applicants have benefited from this, seeing their cases approved earlier than originally projected. With the new internal rules, USCIS appears to be modifying how and when those last-minute reallocations occur, and which cases stand in line to receive those numbers. For some applicants, for example, certain EB1 or selected EB2 cases, this could potentially speed up outcomes. For many others in the long EB2 and EB3 backlogs, especially those who were hoping that reallocation at the end of the year would be their opportunity, that path may now be far less predictable. The same turbulence is also being felt on the family-based side. Categories such as F1, F2A, F2B, F3, and F4 are experiencing shifts in movement. For instance, F2A, covering spouses and minor children of permanent residents, had been moving with some encouraging progress recently. Under the new modeling and allocation approach, especially for heavily backlogged countries such as Mexico, forward movement may slow considerably. For spouses and children separated by borders, these are not just numbers on a chart. They reflect more months or years of living apart or in uncertainty. In the F4 category, for siblings of U.S. citizens from some countries, projections suggest that movement may be extremely limited under the current framework for an extended period. So, what can you actually do in response? This is where the practical part begins. Think again of someone like Timothy. When he learned of these developments, the most effective thing he did was not panic. Instead, he reached out to his immigration lawyer and asked a very specific, practical question. What is the current status and validity of every document in my file? And is there anything we should update or refresh before these changes fully impact processing? That single question led his attorney to notice that one of the documents attached to his adjustment of status package, for example, a medical exam or another time-limited document, was approaching an expiration date that could have become a problem under the new timing. They were able to address it proactively, avoiding what might have become an RFE or a significant delay. A short conversation potentially prevented a delay of many months. This leads us to the key action step you can take right now. Conduct a personal audit of your case. Gather every document related to your immigration file. Check the expiration dates on your medical exams, police certificates, if applicable, civil documents, translations, employment authorization, EAD, and advance parole. Look at the current visa bulletin and compare both the final action dates and the dates for filing to your own priority date. Confirm which chart USCIS is currently following for your category. If you are working with an attorney, send them a brief, focused message today, asking them to confirm that your case strategy still makes sense under the updated rules and whether any documents should be refreshed now rather than later. If you are navigating this without a lawyer and your situation is complex, this may be an appropriate time to consider at least a one-time consultation with a qualified professional. This is not financial or legal advice, and you should do your own research and consult a licensed immigration attorney for personalized guidance. But taking proactive steps like this may reduce the risk of surprises later. For those asking about out-of-status situations or undocumented presence combined with a qualifying U.S. citizen or permanent resident family member, there are separate changes affecting how unlawful presence waivers interact with consular processing and timelines. That is a complicated area that deserves its own dedicated explanation. We will be covering that topic in detail in an upcoming video here on US Updates Hub, so if that applies to you or someone you care about, make sure you're subscribed and have notifications turned on so you don't miss it. Before we wrap up, it's important to acknowledge the emotional reality behind all this. Immigration is not just paperwork or charts. It is real life, real families, real sacrifices, and years of uncertainty. Every small movement in the visa bulletin, every update in a USCIS policy manual, every processing delay or acceleration has human beings on the other side. If you are in the middle of this, if you are waiting, anxious, or simply exhausted by the constant unpredictability, you're not alone. Here at US Updates Hub, our goal is to give you clear, honest, and practical information that can help you navigate the process more confidently. Not to scare you, but to prepare you. So here are 3 steps you can take today. First, verify your priority date against the most recent visa bulletin and know exactly where you stand on both the final action and filing charts. Second, audit your file for any documents that may expire within the next 12 months and mark those clearly so you can renew or update them in time. Third, if you have legal representation, contact them briefly to confirm that your case remains on track under the new framework. If you do not have an attorney and your situation is complex, consider whether now might be a good moment to get professional input. None of these steps can eliminate backlogs or policy shifts, but they can put you in a stronger position, more informed, more proactive, and better prepared for whatever comes next. If this video gave you even one new piece of clarity, please take a moment to like this video so that more people in similar situations can find it. If you're not already subscribed to US Updates Hub, consider subscribing now. We work hard to cover these changes quickly and accurately so you can stay ahead of developments that might affect your case. And finally, let us know in the comments which part of the system impacts you the most right now. Employment-based routes, family-based categories, or something else. Your questions and experiences help shape the videos we make next. There is a lot more coming, and in this environment, staying informed is one of the most valuable protections you have.